Welcome everyone. Today we are going to go over our con law workshop. And as I was discussing to the class before we started, con law is a very difficult subject on the Florida bar. It's very difficult because there's no singular path that allow you to answer the question. You really have to use what I call the Rolodex approach and just know all of the different considerations to con law, and then read the essay, see what the essay is asking for, and apply the most pertinent ones. There are certainly ones that come up more often than others, right? I think about standing, justiciability, and state action as like the initial thought. Is this even a constitutional concern? Then I think about due process and equal protection, First Amendment, 14th Amendment, and Fifth Amendment. Just thinking about First, Fifth, 14th, and equal protection, due process, and fundamental rights, strict scrutiny, intermediate scrutiny, rational basis, freedom of speech considerations, deprivation of everyone's rights if it's due process, or deprivation of a targeted class if it's equal protection. Those are some of the main things that come up. Vagueness and overbreath, you can always kind of argue. And then you got to look at the lenses, the federal lens, the Florida lens, and the con crim lens, which is the Fourth, Fifth, and Sixth Amendment. And just do your diligence. If it's a federal question, it could be 10th Amendment, 11th Amendment, sovereign immunity, state sovereignty. Just to be clear, state sovereignty is 10th and sovereign immunity is 11th. It could be anti-commandeering clause on the 10th Amendment. It could be commerce clause or dormant commerce clause. There's a lot of federal considerations. If it's a state Florida lens, we got to remember enactment of a law in Florida, the single subject law. We got to remember homestead exemption and sunshine law, constitutional considerations of defamation, general law, special law, general law of local application, chartered versus non-chartered county, a whole lot of Florida considerations. And then we have the con crim law considerations, which could even be crimes like murder, arson, burglary, robbery. It could ask you to write about them, which should be pretty common sense from studying, multiple choice, federal and Florida criminal law. But there's a website, it's called Hornsby. He's a Florida attorney named Hornsby, Hornsby. I'll put a link in the chat at some point or in the classroom, Hornsby, and he goes over the Florida laws, especially murder, first, second, third degree murder. I'm a big proponent of this guy Hornsby and his approach on crimes. With Florida con crim approach, it's not only the crimes, it's also Fourth, Fifth, Sixth Amendment. That's right to privacy, which is heightened and expressed in Florida. That's your Fifth Amendment due process, Fifth Amendment takings clause, Fifth Amendment right against double jeopardy, Fifth Amendment right against self-incrimination, and Fifth Amendment right to counsel, Miranda rights. It could be Sixth Amendment, right to counsel after adversarial proceedings have begun, confrontation clause, and right to a speedy trial. Remember with Fourth Amendment, that's going to be the probable cause, search and seizure, exceptions to needing a warrant, the SPACES acronym, search instant to arrest, plain view doctrine, automobile exception, consent, exigent circumstances, and stop and frisk. Right? We want to know about the warrants and all those things. That's why con law is hard as can be. 3 different lenses, and within each lens, a lot to learn, a lot to know. What I want to do today, spend an hour and a half with y'all right now, going over essays and kind of for volume's sake, so you can see all the different things that get tested on the Rolodex. You have the questionnaires. I'm going to finish writing my course guide for y'all to read this week. So I'll have, 3 lenses in narrative form for you to read, but I would just really focus on writing the 2 essays that are assigned by Monday and making sure that you've written all the 6 essays that have been assigned so far. So 8 essays should be submitted by Monday. And today's lecture is going to be a workshop going over previous essays. Sound fun? Yes. All right, I'm going to share my screen. And let's see. Can everyone see what I'm looking at?
Yeah.
All right. Let's start with the year I graduated high school, 2008. And let's just take a look at one, right? There's no major plan to this. This is just, let's see what's tested and let's learn together. So here, discuss the challenges that wife can make under the Florida Constitution and the likely outcome of the challenges. Okay, excellent. So we represent wife who filed a petition for dissolution of marriage on July 5th, 2007. After the trial, the circuit court entered a judgment dissolving the marriage, distributing the property, and providing for alimony and child support. The family had sufficient assets for review and judgment in accordance with the act, and husband has filed a petition with the governor's office to review the judgment. Wife, however, is opposed to such review. Okay, so this might have to implicate a lot with family law. They don't do the best job of always labeling these, but maybe it will have Florida common law considerations too. One reason why they test Florida common law and family law together is because you do have a constitutional right to raise your children in Florida. All right, let's see what's going on here. So representative is a duly elected member of the Florida House of Representatives. Representatives believes that wealthy individuals are unfairly treated by the courts when they are involved in dissolution of marriage litigation. Now I want to ask a question. Why did they say wealthy individuals are unfairly treated? What does that seem to implicate?
Probably the 14th Amendment, the equal protection rule.
Absolutely. And what do we know about wealthy people?
Well, it's not any of the first two suspect classes. So the first suspect classes would be like race, alienage, national origin under federal law. And Florida, it includes physical disability. Whereas the second level of suspect class is gender and illegitimate child, and rational basis for everything else. So rational basis would apply for wealthy individuals.
Fire. Amazing. I was just looking for, wealthy people, not suspect class, rational basis. But what you did was get all the points in that discussion. Everyone should actually take note of how Gabby answered that question. You don't always have to answer a question like that in class, but on an essay, that is exactly how you should do it. Why are wealthy people only afforded rational basis review? Because this is the standard of review discussion. Excellent job. So as a result, representative promised legislation that provides for the following: where a marriage is dissolved by final judgment by the appropriate circuit court after trial, and the parties had an aggregate net worth of $5 million or more at the time of filing of the dissolution petition, the judgment shall not be reviewed by appeal. Instead, the governor of the state of Florida shall conduct a de novo review of the record and circuit court's judgment by executive order, affirm or reverse the judgment. Beautiful. Anyone, and Gabby, I'm going to ask, not you because you are leading the class so well, but does anyone else have an idea of what issues this may implicate?
Would it be separation of powers because the governor is performing the duties of the judicial?
That is exactly what I believe. This is the hardest thing I think to spot on con law essays because they sneak it in there. It's going to be this concept of separation of powers, encroachment, usurpation, entanglement. I explain it like this: the interplay between the United States and the states of America, right? We are a sovereign nation, is very similar to the interplay between the state of Florida and the counties in Florida. And the interplay between the counties in Florida is pretty similar with the counties and the municipalities, right? It's almost like if you look at an atom and the neutron is being, circulated by the revolving electrons and protons, looks exactly like the solar system and the sun and the planets. Everything is kind of a microcosm of each other. So you understand encroachment at a federal level, you should be able to understand it similarly at a Florida level, that we cannot allow the Congress to make judiciary decisions. That's a violation of the separation of powers. That's encroachment. There are specific duties that are reserved for the executive branch, the legislative branch, and the judicial branch. And I think that we all know this, but it's hard to see it on an essay. So I agree. I think this is an encroachment issue. And just, to save time, this isn't really about issue spotting. This is about volume. We'll see how the model answer handles that. But I do think that's an encroachment issue. I also may see access to courts issue. I'm not sure yet, but it does say like you need to have $5 million, XYZ. Maybe that would implicate a Kluger style defense, but I'm not so sure if it's access to courts. I definitely think separation of powers. Anything else anyone notes in the first paragraph that would be an issue? Let's continue. Representative had difficulty finding sufficient support for his bill, but agreed to an amendment that increased the criminal penalty for domestic battery when the battery is witnessed by a child 10, 12, or under. So he had difficulty finding support, but he agreed to an amendment that increased the criminal penalty for domestic battery when the battery is witnessed by a child ages 12 or under. Does anyone know what that might implicate?
I believe you need like a 60% vote for an amendment. No.
Potentially, it could be the voting. I'm thinking maybe it has to do with having more than one subject on the bill.
Oh, no log rolling.
Yeah, it doesn't seem like log rolling. Nice. I think it has some log rolling implication. If everyone knows what that means, log rolling, that's violating the single subject. That's like, I'm going to pass a bill about, littering in Coconut Grove. And then, by the way, an amendment to this bill is $5 million will go to the Miami Dolphins. Like totally log rolling. How'd you throw the Dolphins into the littering bill? This is the same thing, I think. It's single subject. We're supposed to be talking about dissolution of marriage, but now we're talking about domestic battery, potentially problematic. As so amended, the bill was passed by the Florida House of Representatives and the Florida Senate and presented to the governor for signature on March 9, 2007. So just in general, we should understand, how bills are passed, enactment of a law in Florida, that whole conversation. We've discussed this, but in order to enact a law in Florida, it has to have a clear title, a single subject, an enactment clause being enacted by the state of Florida. It needs to have bicameralism to be enacted, read in each house 3 times. It needs to be related to the health, welfare, and morals of the people of Florida. It can't be vague and overbroad. And then we need to understand that Florida does not have a pocket veto. The governor has to actually sign it. If he doesn't sign it, then it does become law. I had to clear that up. In federal law, if the president does not sign it, that's called a pocket veto, and it does not become law. He has to sign it for it to become law. In Florida, that's not true. If he doesn't sign it, then it does become law. So it's so amended, he has to actually veto it for it not to become law. As so amended, the bill was passed by the Florida House of Representatives and the Florida Senate and presented to the governor for signature on March 9, 2007. The citation name of the legislation is the Dissolution of Marriage Review Act, the Act. The laws identify the beginning of its full title, an act relating to domestic relations, right? Clear and concise title. I don't know, domestic relations? No, dissolution of marriage. Very problematic. The full title is lengthy. We don't like that. It's got to be clear and concise and identifies those existing provisions of Florida statute, which it amends or repeals. Totally problematic with how a bill or law should be enacted. If anyone wants to have some fun in their life, go watch that clip from elementary school. I'm just a bill up on Capitol Hill. I actually think that might clarify some issues that people have. On April 20th, 2007, the governor vetoed the act. So how long was that? It was presented on March 9th, and it was vetoed over a month later. The Florida legislature adjourned sine die. I don't know how to pronounce that. Sine die has got to be without coming to a resolution on May 9, 2007, without taking further action on the bill. They love to do that in Florida essays, throw words at you you've never seen, but look how the context clues can tell us without taking further action, without resolution. The act provided for an effective date of July 1st, 2007. So they're really getting into the dates here. Does anyone have any insight about why the dates are important? Someone said 60 days. Again, we'll see. Your wife,
I think it might be, oh, sorry.
No,
I
go
think
ahead.
it might be the 7-day requirements for the governor vetoing the act also. That's why
Yes,
the date.
excellent. Excellent. That 7-day veto requirement will be implicated. All these things, this is a tough essay. For sure, this is a tough essay. Aren't you glad that we're going over it? We're going to read the model answer, and you're going to see how you would answer this so you don't get blindsided on test day. That's why I'm teaching you all this skill. Just read essays, ponder them, and then read model answers for the sake of reinforcement and repetition. That's your medicine. Reinforcement and repetition is your medicine. Okay. So we already kind of read what's going on. Let's see what the model answer is. There are a number of challenges the wife might consider. They will be addressed in order of facts. First, there's an equal protection issue. This law was created to arguably protect the wealthy, but wife could argue it is also to benefit. But wife could argue it is to benefit the wealthy. As a class of people being treated differently, wealthy people do not fall under the categories of protection requiring strict scrutiny, discrimination based on sex, religion, ethnical or race background, or disability. Therefore, under both the U.S. and Florida constitutions, a class based on wealth will be subject to the rational basis test. It's the goal of the law rationally related to any legitimate purpose, and the burden is on the plaintiff, wife in this case, to prove otherwise. The government may argue that this law legitimately provides needed protection for class of people that appear to receive unfair or biased treatment in the courts. This would be the only argument wife may not overcome as rational basis and an easy standard for the state to meet. Wife's best counter would be that the basis for protection of wealthy is not accurate and therefore the protection is not needed. She could further argue that this law discriminates against the opposing spouse, but the result is likely the same. Excellent job with what Gabby said. Gabby said this was wealthy. It was just like I told the class before the recording. They use buzzwords to like tee it up. They put the ball on the tee for you to smack out the park, right? They said targeting wealthy people. If that doesn't trigger scrutiny levels in your mind, that's problematic because it should, right? Wealth is not a suspect class. Age is not a suspect class. Gender is an intermediate class. Race, alienage, and national origin and disability in Florida are suspect classes. Excellently done. Okay. All right, separation of powers. I think this was Jacob who mentioned this. If I'm correct. The wife's next argument is much stronger as it's based on the separation of powers. I want everyone to listen very carefully to this. The separation of powers argument is provided by the Florida Constitution. The Florida Constitution provides that the three branches, legislative, judicial, and executive branch, each have their separate and specific functions and cannot be directed, encroached, I love that word, or interfered with by one of or both of another branch of government without specific authority designated in the Florida Constitution. This is similar to the separation of powers under the U.S. Constitution, but more specific and stringent in many regards, especially in the realm of executive branch encroachment on the judicial branch, as appears to be the case here. The governor, as part of the executive branch under the law, and think of the governor like you think of the president, right? He's the king of the state, kind of. Don't use that word, king of the state, but just kind of think of it. The governor, as part of the executive, or queen, the governor, as part of the executive branch under the law, could be encroaching on the judicial branch's area of responsibility under the Florida Constitution by becoming the appeal agency for the circuit court. Under the Florida Constitution, the District Court of Appeal, the DCAs, has specific jurisdiction for appeals of circuit court judgments. Wife has a very good cause of action that this provision of the law makes it unconstitutional under the separation of powers provision of the Florida Constitution, as the executive branch would be encroaching on judicial branch's specific jurisdiction and duties. The legislative branch has police powers to make law, but cannot pass legislation to become law that would require any branch to encroach, they use that word so many times, on another branch for their duties set forth in the Florida Constitution. Encroachment is stepping on the toes of another branch. Usurping, is taking the powers from another branch. Those are good words. You could also use words like entanglement or entwinement, but I love the word encroachment. Separation of powers, encroachment, or usurpation. Those are big words, big, sexy words. This test comes down to how good is your knowledge of big, sexy words, right? Because if you know what they mean, you know how to write about them, you're going to get a great score. Okay, access to courts. I did mention this, right? Wife can further argue that the law denies their access to courts. Access to the courts is a specific right to the people in Florida under the Florida Constitution. These rights are similar to the Bill of Rights found in the U.S. Constitution, but are more enumerated and specific. One of these articles of rights is the rights to access of courts. The Florida Constitution provides that the District Court of Appeals shall hear appeals made from the circuit courts. Wife should be allowed to appeal any final judgment of her dissolution of marriage to the respective DCA. If the husband wants to appeal, it should be heard by the DCA, not another branch of government. The dissolution of marriage is not a simple dissolution. There are children, child support, and alimony. So the proper venue is a circuit court. The proper venue for an appeal would be the respective DCA. The legislation specifically takes it out of the DCA, thereby denying wife access to courts. States could argue, and this is the Kluger Doctrine, they didn't mention it, but this is indeed the Kluger Doctrine. States could argue that an alternative venue is provided and is for public necessity. That's the Kluger argument. A Kluger defense is you could overcome denial of access to courts or abridgment of access to courts for an overarching public necessity. That is called the Kluger defense in Florida. To be somewhat compelling as counter arguments, but neither should hold water here, as the venue is appropriate under the separation of powers argument, and no public necessity seems to be involved unless you are wealthy enough to be worth over $5 million. I kind of like that term, hold water. It's kind of nice. Like, it doesn't hold water. It's not that good of an argument. That's why I like reading these model answers, because it helps you with your language. You know, people read my courts guide, my essay guide, and they're like, oh wow, you have a really strong handle of the language. There is an undoubtedly true statement. There has never, ever in the history of literature been a great writer who was not first a great reader, right? You have to be a great reader to be a great writer. So if you want to write great essays, you have to read great essays. I hope that that is sticking. Okay. Number 4. So we talked about the 3 things so far, which we were on top of. Equal protection, wealth is not a suspect class. Separation of powers, we are encroaching upon the judiciary branch. Kluger Doctrine, access to courts, not good. Access to courts is a fundamental right in Florida. Remember, fundamental rights are the Camper mnemonic: contraception, marriage, procreation, education, the right to raise your children. It's going to be race, alienage, national origin, and disability are subject to strict scrutiny. And then there's some other things: access to courts, right to vote, right to travel, right to be a candidate on the ballot, right to work is a fundamental right in Florida, right to be in a union, right to unionize. Anyone else know any fundamental rights I might have missed?
Right to privacy.
Right to privacy is an express fundamental right. Excellent job. Good work. Okay. Number 4, wife should argue that the legislation itself as presented is unconstitutional. The Florida Constitution that the legislation as titled should have a single subject, be understood by the public. The title and subject of the legislation be closely related as one topic and not be vague or overbroad. I've read a lot of essays. That's what makes me a good writer. Vagueness and overbreadth seem to be the things that come up the most consistently on constitutional law essays. Federal lens, Florida lens, CrimCon lens, I think they always mention vagueness and overbreadth. In this case, wife would argue that the title of Dissolution of Marriage Review Act and its full title, la-di-da, is too vague and overbroad. The intent of legislation is understood from the facts of the law, and the law is understood from the facts. The intent of legislation is understood from the facts, and the law is understood from the facts. However, reading the title in and of itself could be easily interpreted as having to do with a lot of other domestic relations or family law issues, not what the facts indicate the legislation is about. Additionally, the addition of the criminal penalty for certain domestic violence is completely different subject matter that is unrelated, thereby violating the single subject requirement. Therefore, the legislation as titled and written to include the unrelated criminal law appears to violate the Florida Constitution requirement for the legislative act to be one subject and not vague or overbroad. I am kind of proud of myself that I nailed that single subject, because it wasn't super clear, but it did seem to be like, yo, this was supposed to be about marriage. Now you're making about domestic abuse. Next thing you know, you're going to be putting the Dolphins season ticket holders on this. It seems to be about multiple subjects. Vagueness, overbreadth, all that comes in. We don't like the title. Excellent. Now, this is a good argument here. Number 5. Oh, this is the end of the essay. Short essay, but well written. This is the part that I was interested in about the days and the vetoes. Let's see what they said here. Wife has an additional argument that law was vetoed by the governor and not overridden by a vote of both houses of the legislature. In this argument, the state most likely would prevail in arguing that the governor's veto did not occur. When the legislature is in session, the governor has ways in which to veto a bill upon presentment to him by the legislator. If the governor does not affirmatively veto the bill within the prescribed time, the bill will become law. That is different from federal, where the standard is a pocket veto. Don't worry, I have my treasure. That's where the standard is a pocket veto. You cannot pocket veto. The governor cannot pocket veto. A pocket veto, so y'all know, what's the purpose of it? It's so the president can prevent something from becoming a law without actually taking a stand on it, without, alienating either of his bases or, his lobbyists. The president can be like, dude, I do not want to pass this gun law, but I get money from the NRA. So I'm just going to pretend I didn't see it and it won't get passed. And then the NRA can't be like, the president hates guns. It's a tactical maneuver. You can't do that in Florida. In Florida, the governor has to stand on his word. For what it's worth, I really believe in people standing on their word. I think we should have more laws that require people to be non-anonymous and say what you mean with your chest. All right. In this argument, the state most likely prevailed in arguing that the governor's veto did not occur. When the legislature is in session, the governor has ways in which to veto a bill upon presentment by the legislature. If the governor cannot do a pocket veto. Here, the bill was as an effective date of July 1st, 2007. Therefore, it became law at the time. Wife would most likely not prevail in this argument. Wife most likely would prevail in an argument that acts unconstitutional under the Florida Constitution, that it violates the separation of powers, denies her access to the courts, and violates a single subject rule, as well as being vague and overbroad. Wife probably would not prevail in equal protection and veto arguments. So Gabby was talking about the 7-day rule to veto, but because he didn't veto, it wasn't vetoed and it did become law. So, hey, this was a short essay, man. Super short. I tell people shoot for 2,000 words, 10,000 characters, but that's because I know people are going to be people and write things that aren't that good. If you can write everything perfectly, it doesn't have to be that long. It's just, this is an example. They wrote a perfect essay. They didn't write anything extraneous, but everything they did write was absolutely on point. I would give this a passing score. I wouldn't give this, personally, I wouldn't give this a 90, but I'd give this definitely a 78, 82. Very, very solid essay. Anyone have any questions about this essay? All right, Gabby, you're on camera right now, so I want you to pick a year, any year. I'm gonna pick a charger, any charger.
Okay.
It could just be a year between 2003 and today.
Maybe 2013.
All right, 2013. Sorry. My charger was not where I thought it was. All right, 2013. Let's do it. That's 2012. 2013. All right. So in 2013, I was starting my JD MBA at the University of Miami. I'd done 1 year of law school and decided my educational thirst was not being quenched and enrolled in the MBA program. 2013 was a tough year for the kid. All right, let's see. 2013, here we go. Family law, Florida common law. I'm not going to do that one because it's probably mostly family law. Let's take a look at this Florida common law one. And again, there's no real rhyme or reason to this order because on test day, there's no real rhyme or reason to what you're going to get. I am not in the business of predicting essays. There's not that many subjects. So if someone predicts them all right, it's like saying someone bet on the Dolphins game and got it right and they're a genius. Like there was only 2 teams that could have won. It's not really worth it. It's worth preparing for everything, prepare for war and then you fight the battles that come to you. But preparing for war is comprehensive. And that's what we're going to do. All right, so let's look at this one. Ew, Article 3, UCC, gross. That's not what I thought we were looking at. You guys are very lucky you don't have to write about commercial paper. I mean, not really. I like writing about commercial paper, but I know that y'all don't really. This one, I believe we might have done in the November course. Does this look familiar to some people who are in my November Essentials course? If not, don't worry. Maybe it's not. Okay, prepare a memo addressing first whether the bill ever became law. Then assume the bill did become law and discuss the constitutionality of the law and its provisions under the Florida Constitution. In your memo, also include discussion of any ethical considerations for attorney that arise from plaintiff's efforts. So here, how would we set this up? we would clearly set it up the same way that it's being presented. There's 3 questions, therefore there's 3 answers. I would be, did the bill ever become law? I would be constitutional issues. I would be ethical issues. And we probably won't do ethical issues today. I know that I say ethics is so important, and it is. And a lot of people are freaking out. Like, Andrew, how am I supposed to write about ethics yet? Ethics is easy. We can do ethics in a week. We can master ethics. You guys are going to be monsters of ethics. Don't be scared about ethics. Be more scared about common law and real property. I want you guys to spend all your time in the next 2 weeks, common law, real property, and we'll get into civil procedure. Like, these subjects are the meat and potatoes, or for my vegetarians, the eggplants and jackfruits of this test. It's pretty good, right? These are really important subjects that are really, really hard. Ethics, you look over it a couple of days and you got all the main points. It's not like that. So we're going to focus mostly on common law and real property. So don't get mad at me that I haven't done ethics yet. There is a purpose to it. I've been doing this course for so many years, and I've tinkered it every single time, that this is the best version of it right now. If I find a better version for July, we'll work on it, but I'm not going to do ethics yet. Okay, so we know how we are going to set this up. Did it become law, constitutional issues, and then ethical issues, which we won't talk about today. So worried about the recent oil disaster. This is really reminiscent because when I went to college in New Orleans and there was the oil spill when I was working in the industry. I actually got a check because I was impacted. Worried about the recent oil disaster, Florida's governor issued a proclamation for a special legislative session, which stated in part. Does anyone know what a special legislative session is?
Yes, a special session is called when they are trying to tackle a specific issue, and it's only to discuss that specific issue.
Exactly. And that's the time where, we would need a 2/3 vote from each house to discuss something different than what it was called for. It's really like the governor calls a special legislative session to talk about one thing, and we're going to figure this one thing out. All right. So obviously in our essay, we're going to tell the reader what a special legislative session is, when it can be called, why it can be called, how it can be called. But again, we'll let the model answer tell us more about special legislative sessions. So it's stated in pertinent part that the legislature is convened for 1 week for the sole and exclusive purpose of considering legislation to reduce the negative impacts of offshore drilling. All right, seems to be for a sole and exclusive reason. On the last day of the special session, under the governor's proclamation, Representative Polk from Polk County, that'd be like my name being Dade, drafted and convinced the House to consider a bill to limit medical malpractice litigation in Polk County. To limit medical malpractice litigation. Representative Hardy from Hardy County, again, that'd be like my name being Dade, agreed to vote in favor of the bill in exchange for a provision increasing the state tax revenue by requiring yearly ad valorem taxes on motor vehicles registered in Polk County. Yikes. Any thoughts about this? The first part about limiting medical malpractice and the second part about the taxes?
I'm thinking that about the welfare, that you can do laws for that are good for the people, safety. Like, that's what I'm thinking. The police.
Yeah, fair enough. So it's Polk County. So an act relating to Polk County.
Home rule power, sorry.
Yeah, home rule power. Maybe this is a special law because it's only relating to Polk County. So general law would be the whole state. Special law is just to Polk County. General law special application would be based on population. That's a good one. I think we probably would consider the targeted class here, right? Like maybe equal protection or due process. Medical malpractice litigation, when I hear that, I always am thinking about access to courts. Like, are you making it more difficult for people to get to court based on this? The big one for me, though, is the state's tax revenue requiring yearly ad valorem taxes on motor vehicles. So can the state tax property?
No, only the counties can.
Only the counties can tax property. But now I have another problem with this, man. Is a fucking tax on motor vehicles even ad valorem taxes? That's
No.
questionable to me. I don't think it is. I think ad valorem are property taxes, like on your houses. I think that's a personal tax. So I think that, and that's what I really think is so tough about con law. You read these sentences that whoever wrote them is like maniacally laughing. You're like, oh, this is so ridiculous. This could never happen. But when you read it, you're just like, you don't know which sentences are maniacally ridiculous and which sentences are just normal. Oh, that's just how laws are made. That seems to be a little bit ridiculous. Like, you're gonna have a law where the state can collect a tax from my car. Like, what? Counties can collect property taxes. I don't know who's gonna collect this tax. That's problematic. But I agree with what Grace was saying. We're definitely, the first question is literally just asking us about enacting a law in Florida. So that's going to be the same, clear and concise title, single subject, not vague or overbroad, related to the health and welfare and morals of the people, enactment clause, right? Being enacted in the state of Florida. All those things are going to come into play. This seems to not be so different of an essay than the last one, which is kind of good because I told you, if you notice in today's workshop, issues that come up repetitively, that's a sign of issues that come up repetitively. And that's a indicator of issues that are likely to come up on your test. So you should really focus on them. Clearly, enacting a law, a bill or a law, or turning a bill into a law is important. All right, let's look at, go ahead.
I actually have a question. From looking at the paragraph, like those two sentences, so those arguments, I could definitely see them being like potential paragraphs, but I also thought like in general, aren't you only supposed to be talking about a single subject for the bill? Because
Yes,
if you're agreeing to vote in favor of the bill in exchange for another provision, wouldn't that make it like vague?
totally. Single subject is implicated, vagueness and overbreadth is implicated, and just the whole idea of like, wait a minute, you weren't even supposed to be talking about this during the governor's special session. So like, this is a ridiculous proposition and it's heavily plagued, and we're going to discuss all of them. And yeah, I do think that one of the problems that we can see is that there's more than one subject being spoken about.
Right. That's what I thought, like, at first glance. I thought there's too many subjects that they're talking about.
All right, so let's check out the actual bill. And here, this is what I was saying. When you asked me, Gabby, at the beginning of class, how should we try to write these essays? I like it like this. Section 1, do. Section 2, do. Like, when you're saying constitutionality of the act, if you can divide the act up by its sections and address each section individually, that's a really good approach, or like each claim individually. You kind of want to break things up into sizable bites, and that's a good bite for me. Section 1, the provision that act should be applicable only to Polk County, Florida. Well, that's general law, right? Sorry, opposite. That's a special law, right? Because it's applying only to that county. So, okay, we could talk about that. We can even talk about the title and the subject and things before that. All right, let's have section 2. Anyone desiring to see, I knew it. This is access to courts. Anyone desiring to file a medical malpractice lawsuit must post a bond with the clerk of court in the amount of $1 million before filing a complaint alleging medical malpractice. If that doesn't signify access to courts to you, please make sure it does as of this moment in time, right? Like, they're making it difficult for you to go to court. You got to post a bond of $1 million just to file a suit. Like, damn, that's hard. And then I would say, is it a suspect class? Like, are they targeting people? It doesn't seem to be, but maybe there's equal protection due process issues for sure. Any motor vehicle registered in Polk County shall be subject to a yearly ad valorem tax of 0.5% of the vehicle's fair market value. The ad valorem taxes shall be deposited into the state's general revenue account. Absolutely not. Absolutely not. Why? Because that's a county right to tax for ad valorem taxes. The state has no right to tax me for property taxes. If they did, I'd be broke because I'm already paying enough to the county. All right.
I have one
Good.
question here. I know this is a Florida con law lens, but doesn't that triggers the, I'm sorry, I'm having trouble.
Takings, Fifth Amendment.
The commerce clause, the other one that the states cannot, because you are
The
making
dormant commerce clause.
dormant. Yeah, dormant.
Yeah.
Because
As a
like
reach,
impacting, right? It's cars.
it's a
trucks.
reach because it's only applying to vehicles registered in Polk County, so it doesn't really
Oh,
impact discriminate against interstate commerce. But there's always an argument. I mean, the Commerce Clause and Dormant Commerce Clause are far-reaching, and there is I would say a pretty weak Dormant Commerce Clause argument here. Maybe something mentioned and leave it, but yeah, I don't hate it. I think I could defeat it. But again, just because an argument can be defeated doesn't mean you shouldn't mention it. You should mention it, tell the reader why it's defeatable, what do they say, why it doesn't hold water, and then keep it moving. But yeah, I like that potentially. And that's another thing. You're not gonna know you're not gonna know on test day whether it's Florida Con Law and Ethics or whether they don't give you a subject. That would really help, right? But they don't. They don't do anything that would really help you. Immediately after the bill's passage, the legislature adjourned for the summer months. As presented to the governor the same day as passage, disgusted, he went on a 3-week vacation. He never approved and signed the bill, nor did the governor veto the bill. The exact same thing. This is interesting that we happen to do back-to-back essays that were similar. Same thing about there is no pocket veto. They're saying, did it ever become a law? It seems like it became a law because he never vetoed it. And he had 7 days to do it, and this was 3 weeks later. All right, 2 months after the vacation ended, he suffered serious injury. Okay, standing, right? Do they have standing? Yes, because they suffered an injury. Plaintiff has sought attorney's representation, so there's state action because it's it's justiciable because it's live controversy. Again, that whole standing, justiciability, state action, that could be 1 paragraph. Maybe it's 2 if it's really important, but it's like that's unless you see that they're really talking about that being an issue, it's really not an issue. It's just something worth noting. All right, and then they do some, ethical things. Let's see what we got here. So whether the bill became a law, as a preliminary matter, and here everyone listen up about special sessions. As a preliminary matter, the governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope. In the absence of the requisite vote of the members of the House and Senate, 2/3 vote, no new matters may be addressed during a special session other than those from which the special session was called. Let me read that twice because that's all you need to know about a special session right there. As a preliminary matter, the governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope. In the absence of the requisite vote of members of the House and Senate, 2/3 vote, no new matters may be addressed during a special session other than those for which the special session was called. So the governor can call a special legislative session. It's got to be about one thing and one thing only, unless 2/3 vote from each house to talk about something different. Here, the facts are unclear. See, and this comes up a lot. You have to say, like, we don't know if the newspaper gave them, if he gave the newspaper retracted within 7 days. But if they did, you have to learn how to do that, how to write about hypotheticals quickly. Here, the facts are unclear regarding whether a proper vote was held to address the issue of medical malpractice, litigation, taxes on motor vehicles. Absent such a vote of approval in both House and Senate, the legislature was not empowered to consider any matters other than the impact of oil drilling. However, if the requisite approval was achieved in the House and Senate, then the consideration of this bill was valid. Assuming that the bill was valid, it did become law because the government did not exercise its veto power. Listen to this one. When a bill is submitted to the governor for signature or veto, he has 7 days or 15 days if submitted at the end of a session. That's a nuance I didn't really know. To exercise his veto power. Because the governor never exercised veto power within this time, the bill became a law on its effective date. I'm sure there's more than a few people in here who learned this today about there being no pocket veto in Florida. Like, you might have heard that, but we've just reinforced that twice. This part is hugely important. Formalities of passing an act. Each law must comply with certain constitutional formalities in order to be valid. First, the act includes a short title that sufficiently describes the subject matter of the law. Second, there's an enacting clause. Finally, the purpose for the act was likely in accordance with the legislature's authority to pass laws for the general welfare, health, safety, and morals of the public, as the purpose of the bill deals with litigation efficiency and raising revenue, though the means by which the purposes are achieved are questionable, as discussed below. However, the act violates the single subject rule. Excellent job. To comply with the Florida Constitution, a law must only cover one subject. Each component part or aspect of a law must have some natural relation to an overall scheme. Here, the legislator would not likely be able to show that the ad valorem taxation of vehicles is naturally related to enhancing the efficiency of med-mal litigation. Thus, the single subject rule is likely violated. Good job, Gabby.
Andrew,
Section-
I'm sorry to interrupt, but Hector's in the waiting room.
Oh, for sure. No, don't be sorry to interrupt on someone in the waiting room. I don't want people
Thanks.
waiting.
I think it booted him. Thank you.
You're fine.
Also, Andrew, I think I mean, reading this, I think I answered my question because the law must be taking account the safety and, you know, all of that, instead of talking about the dormant commerce clause, I just need to say that.
Well, yeah, I mean, the Florida law about formalities of enacting a law requires that it be related to the health, safety, welfare, and morals of the people. Your consideration of the Dormant Commerce Clause means that states cannot enact legislation that unduly burdens interstate commerce or, on its face, discriminates against interstate commerce. So here, I was just kind of listening to you saying like, okay, well, if they tax this car and then that car drives across the Jordan, like there might be some nexus to unduly burdening interstate commerce. But as I said, it doesn't hold too much water. But good. I'm glad that you're participating, learning, and thinking, man. Thinking is everything. Thinking is the greatest freedom you could ever have. All right. However, the act is likely violating a single subject. Now let's talk about this. Section 1 indicated as a special law. They did exactly what I recommended. They broke it down by section. Boom, boom, boom. And talk about the considerations of each section. Section 1 indicates that's a special law, right? Like it wasn't an issue. It was just, hey, I bet you most people don't know that. Let me talk about it. That's kind of the way you want to think. You're a brainiac and you want to demonstrate how brainy your brain is. Section 1 indicates that this is a special law. A special law, unlike a general law, is a law that only applies to particular geographic areas in the state. Special laws are permitted so long as voters in the affected area are given notice of the proposed law and a referendum is held. Additionally, a special law, as well as a general law of local application, which does not require notice and referendum but applies to certain areas based on classification schemes such as population, cannot cover certain subject matter the Florida Constitution expressly prohibits. This is a big sentence right here that honestly, I don't know if I could have recited before this moment. So I'm going to read it carefully and try to stick it in my own mind. Prohibited subject matter includes taxation, elections, petite juries, conditions precedent to bring civil or criminal claims, venue rules, and rules of evidence. Special laws cannot cover them. They are expressly prohibited by the Florida Constitution. Those are Florida state subjects. Taxation, elections, petite juries, conditions precedent to bring civil or criminal claims, venue rules, and rules of evidence. That's a good sentence right there. And that's why I think reading the model answers is really good. Because you get a lot of people who know little intricacies that you might see it in an outline, but you don't realize that it's something that can get you points. So anyway, we were on top of section 1. Make sure everyone knows the difference between a general law that applies to the state uniformly, a special law that applies only to a specific county like Dade County or Polk County, or a general law of local application. General laws of local application do not require a referendum or a vote. Special laws do require a referendum or a vote. General laws of local application are based on population. So if the law is passed where any county with a population over 1 million has to, you can't have cheetahs as pets. Well, there's only like 1 or 2 counties in Florida with populations over 1 million. So then you would argue, although this is a general law of local application, it's actually a cloaked special law and should require a vote or referendum. That's kind of like just a discussion you could have. But again, understanding what this is all about. General law applies to the entire state. Special law just applies to a county and requires a vote. And then general law of local application is kind of the way the state getting around the voting requirement by saying it's only going to apply to special populations. But if it seems targeted to only a certain county, it might actually be a special law, and you should argue that it does require a vote. But just know at its core what those 3 laws are. General law to the state, special law to a county requires a vote, and general law of local application does not require a vote and is based on population. Now we have learned a new sentence. Prohibited subject matter for special laws include taxation, elections, petite juries, conditions present to bring civil or criminal claims, venue rules and rules of evidence. I feel like that sentence could actually get you a lot of points on some essay. I don't know about this one, but there is an essay where they might be like, a county, enacted laws that require, that change the venue or that require this condition to bring suit. It's like, actually, that's not allowed. Here, section 1 expressly applies only to Polk County. It's a special law. There's no notice of referendum were met. It's invalid. Again, the facts do not indicate that the notice and referendum requirements were met, but you could say, assuming these conditions were met, it is a valid law. Like, you could go either way with that. Perfect. All right, section 2. This is the one that has the most constitutional infirmities. What a great word, infirmities, right? It means like sicknesses, including an improper infringement of the fundamental right of access to courts, possible equal protection problem, and prohibited special law subject matter. Let's get it. Access to courts. The Florida Constitution provides that the right to access to courts will not be infringed upon and that justice will be administered without sale, denial, or delay. When the legislator significantly burdens this right in a manner that amounts to abolishing a cause of action, a reasonable alternative must be provided unless the legislator can make the difficult showing that a public necessity exists and that no alternative can reasonably be established. That's the Kluger Doctrine right there. Simply put, access to courts is a fundamental right. Florida Kluger Doctrine, we can overcome that and deny access to courts for an overarching public necessity. My best example is the coronavirus. During the pandemic, they were like, can't access courts today because you're going to die, allegedly. Here, section 2 violates the problem of justice being administered without sale and the excessive amount of bond. See, I felt like that bond was wild. That is required constructively abolishes a medical malpractice clause for action for everyone who can't afford to pay what amounts to $1 million filing fee. Even if the legislator could show that compelling public interest existed, there are certainly reasonable alternatives other than the imposition of a $1 million bond to promote the courts. They're saying Kluger would fail. Moreover, courts are especially hostile when faced with access to court problems that don't involve any element of voluntariness on the part of the public. The involuntary nature of section 2 is yet another justification for striking down as unconstitutional infringement of the fundamental right of access to courts. Excellent. Prohibited subject matter. See, this is where they got that little sentence from. As discussed above, conditions precedent to filing a civil or criminal suit are among those subjects expressly prohibited from special laws and general laws of local application. Requiring residents of one county to post bond before bringing a civil malpractice claim violates this prohibition, as posting bond is a condition precedent to filing a complaint based on the plain language of section 2. Excellent. Equal protection. Equal protection comes up a lot on essays. So you should, if you think it's equal protection, just write about it because it probably is. Section 2 also implicates equal protection concerns. The Florida Constitution prohibits discrimination against individuals based on race, alienage, gender, religion, and physical handicap. Any discrimination on these bases will be subject to strict scrutiny, compelling interest in narrowly tailoring. Wealth is not a suspect class. Instead, when legislation draws lines based on people with wealth, we use rational basis. The Supreme Court of the United States, as well as the Florida Supreme Court, have both recognized, however, when discrimination against the poor involves a fundamental right, heightened scrutiny should be applied. Here, the plaintiff can argue that even the rational basis test is not met here. There's no rational relation between this action. The legislator may assert that the high cost of med mal is XYZ. Plaintiff can argue, however, that it's more than just wealth discrimination. It involves the fundamental right to access to court, heightened scrutiny, and it's not likely to prevail. Due process. See, equal protection, due process, they're kind of like the frickin' Fran, they're always coming together. Finally, the Florida Constitution expressly protects the right of both procedural and substantive due process. Listen to this, because this due process is a big part of other essays. So you want to be familiar with it. Substantive due process involves the protection of fundamental rights, and procedural due process protects against unconstitutional deprivations of protected interests without notice and hearing, and protects the right to a fair trial. Infringements of either aspect of due process implicate strict scrutiny review. Here, plaintiff can argue that, as discussed above, her fundamental right to access to courts has been unconstitutionally burdened, and that the legislator will not be able to make the requisite showing to survive strict scrutiny. Plaintiff may also argue that procedural due process involves inherent guarantee of the right to a fair trial, a right that is meaningless if a plaintiff can never step foot in the courthouse due to an excessive bond requirement. So, right, substantive due process, procedural due process, equal protection, those are things you can argue on a lot of con law essays. And then finally, section 3 is constitutionally invalid because it involves taxation. I was hoping they would talk about this, which is on the list of prohibited subject matter of special laws and general laws of local application laid on the express test of the Florida Constitution. Additionally, the state is not empowered to collect ad valorem taxes. Here, the act provides that the county would be collecting ad valorem taxes, which is permissible. However, the funds would go straight to the state. Problematic. Plaintiff can argue that this tax is therefore constructively imposed by the state since the state retains all revenue. Therefore, because the state cannot collect ad valorem taxes, this provision should be unconstitutional. Moreover, right, ad valorem taxes are imposed on real property, not personal property, such motor vehicles. That's exactly what I said, and it goes to the point that they threw out the dumbest thing I've ever seen at me, and I had to write about it. That's hard to do, but that's what they do. They're like, this is an invalid law about a prohibited subject matter. What do you think about it? Well, I think that this is invalid because it's usurping county taxation. I also think that it's totally ridiculous because you're calling it an ad valorem tax, but it's not even a property tax. Therefore, because this is totally dumb, you know what I'm saying? Like, you have to just like accept what they're giving you and take on a very professional, I know I said this is dumb, don't say that, but take on a very cultured response. Like, imagine if someone asked you who's a better cartoon dog, Scooby-Doo or Snoopy, and it wasn't a joke. And you have to think, well, there are considerations, you know what I mean? Like, that's how you got to talk about it. Even though it's kind of dumb questions, you really have to take it seriously when answering and give a great response. So those were two good Florida essays. I'll look at some Florida ones and then maybe a crim law essay. I think. All right, Grace, since I see you, what year is special to you?
Let's do 2004.
You said 2000 what?
4.
Mm-mm.
No?
Let's go closer. Let's go closer because the laws have changed in the past 30 years. Let's go
Okay.
closer to today.
So 2015?
2015? 2015. What was good in 2015?
Huh?
What was going on in 2015 in your life?
I started law school.
Nice. I like this one. I like this essay. I'm familiar with this essay. I'll do it rather quickly because it's mostly torts. But remember that torts and defamation are torts and con law are tied by defamation. So I'm just gonna skip through this one. We'll do another one, but I'll tell you about what happened here. We got this kid. The kid writes on a website, Mr. Smith must die, who's the teacher. And then all the kids go on and they actually, you know what? I want to read this one because it's First Amendment. Let's read this one. Okay. Sorry, I know I'm weird. Okay. So John's parents want to sue school officials and the school district for violation of both John and their rights. Discuss the federal constitutional claims that John's parents may have and any defense is likely to be raised. Mr. Smith, the teacher, my favorite gym teacher's name was Mr. Smith, rest in peace, has sued John and his parents in state court for intentional infliction of emotional stress and negligent parental supervision. So that's the torts piece, the NIED and the negligent supervision. We'll kind of skip that. And then the third piece is ethics. So you see, and this is something that you'll realize as the course goes on, I'm going to start assigning essays that are mixed subject. Not all essays. In fact, I think the majority of essays are multiple subjects. So that's why when people are asking me these questions, like, how do I approach a con law essay? I'm like, dude, it could be a con law property contracts essay. There's no magical formula. You got to just answer the questions and have a strong foundation of knowledge. So this is a good example. This is torts, con law, and ethics. I thought it was going to be defamation, but it doesn't seem to be related to that. It seems to be NIED and negligent parental supervision is actually going to be totally about First Amendment protected speech, public forums, non-public forums, and this kid who hates his teacher. All right, let's get it. John Jones, not the UFC fighter, a student at Southern High School, which is a public school. Why is that important? That's a public school.
It's the forum.
State action, right? Yeah.
Mhm.
This is state action. We're on a potentially, we're at a forum, sure. Create a website on his parents' computer suggesting that his math teacher should be killed. No comment. The website was publicly available and no passwords need to access the site. John uploaded a photograph of the teacher from the school district's website and add a hand-drawn picture of a gun firing a bullet at the teacher's head. You gotta be nice with your teachers. Beneath the picture were printed the words, Mr. Smith must die. John invited any student to join the group to express their hatred of Mr. Smith and to contribute funds to hire a hitman. Okay, first off, this kid, John Jones, has some problems, man. He needs to see a therapist. He needs to really get some things together in his life. But that's not what the question is about here. This is about freedom of speech, right? This is definitely implicating, and I'm going to talk about this tomorrow when I start class, bong rips for Jesus, right? This is implicating that concept of, do you have unfettered freedom of speech in a public school? And the answer is no. You're not allowed to disrupt the educational process. You know, they said bong rip for Jesus was too distracting. The kids couldn't focus on their calculus.
Also,
Jesus.
the internet is a public forum. So,
Right.
and he did it through a website.
Interesting. He did it through a website. He wasn't on school property. There's another case like this about there's a cheerleader and she posted something on Snapchat. This is totally related to these types of cases. Okay, so we know we're implicating First Amendment. We know that you do have a freedom of speech, but we got to talk about if this is going to be protected speech. Numerous students viewed the website and was discussed extensively at school. At least a dozen of John's friends posted comments expressing their approval of the website and liking the photo. Some of the students accessed the website at school and showed it to others. Many students were frightened by the website. Now we're getting into the IED and AD. Within a few days, a student notified Mr. Smith about the website and provided him with a copy of the photograph. Mr. Smith forwarded the information to school officials. He felt so threatened, he took a leave of absence, and school officials replaced him with a substitute teacher for the remainder of the school semester. Southern's principal interviewed John, who acknowledged he created the website and the photograph. Although he expressed regret, he stated it was just a joke. After an investigation, he got suspended for 5 days pending a hearing before the superintendent. Ultimately, a hearing officer appointed by the superintendent found that the photograph and web page were threatening and were not a joke. Specifically, the hearing officer found that the website violated the school district student policy on harassment and intimidation. The policy defines harassment or intimidation in part as any intentional gesture or intentional written, physical, or verbal act that a reasonably prudent person under circumstances would know have the effect of harming a student or staff member. What's wrong with that? That policy.
It's vague and
I agree. What is it even saying? What? The policy provided that violators could be suspended after investigation by school officials. It provided for additional penalties, including being denied the ability to participate in extracurricular activities and other school-sponsored social activities or events. The hearing officer recommended that John be suspended for the remainder of the semester and be prohibited from participating in extracurricular activities and from attending after-school hour functions. The superintendent agreed and imposed discipline. So I'm going to focus on the con law one here. Obviously, there's the NIED and IIED and negligent supervision. I mean, I would argue the parents probably didn't do anything wrong because he's a 16-year-old kid, a kid of ordinarily, intelligence and sensibilities, goes on the internet, and the parents, Grace, you have a kid, does that seem like your fault if your kid goes on the internet and types something? I mean, maybe your kid is younger, but at 16 years old, I think that's the argument we would make. But this isn't about torts, this is about con law. And for time's sake, let's ask the expert himself or herself what they think. See, they set up essays just like me. To, from, re. I like to send up a memo form, and then I like to say what the memo will discuss. That doesn't get you any points. It just helps me, get into gear. This memo will discuss the federal constitutional claims, defenses, and the negligent stuff. The first issue that must be evaluated is whether or not John's parents have standing. Remember I said it's a great place to start. If you have an individual coming up with a claim, let's see if they have standing. In order to have standing, a plaintiff must show an injury in fact. The injury must be actual and imminent and not just speculative. Additionally, the injury must be one that is capable of redress by the courts. A third party can bring the claims of another when that injured person, for some reason, is incapable of bringing the claims on their own, or if the claim is one that is capable of repetition yet evading review, like taking the bar exam or pregnant woman. You can take the bar exam, you can have another baby. In this fact pattern, the son has directly suffered an injury of his rights by being suspended and is an injury that's capable of redress by the courts. Because his parents did not suffer the injury themselves, they must bring the claim in their son's name. The next issue we need to determine before is whether there's been action by the state, right? Standing, state action, justiciability. These are all the things I say at the beginning, just kind of think about. Under the federal constitution, in order for an individual to assert that their rights have been violated on the 14th Amendment, they must show that their rights have been violated by a state actor, as the 14th Amendment does not protect the violation of rights by private actors. As a public school, John can argue that the school is an agent of the state, and that his rights have been violated by government employees. Just because a government provides funding for a school does not automatically implicate them as government actors. The question is how involved the state is with the school, if they're advancing the school's denial of certain rights or simply taking a neutral stance on it. Although states enjoy protection from being sued by a citizen under the doctrine of sovereign immunity, most states waive the right in relation to certain cases, right? That's a key thing too. Florida does have sovereign immunity, but they waive sovereign immunity for operational decisions, for suing a state actor in their official capacity for injunctive relief, or for suing a state actor in their personal capacity for legal relief. It would be pretty tough to be like, under sovereign immunity, there is no claim. Like, I wouldn't say never, but if that seems to be a minor issue, the thought is that it's probably been waived under the circumstance. If it seems to be a major issue, then certainly you would talk about, 11th Amendment sovereign immunity. Okay, under the federal Constitution, the First Amendment, and this is the big thing I want to talk about this essay. Everyone listen up about First Amendment. This definitely comes up, and this is a great essay to learn from. Under the federal Constitution, the First Amendment grants citizens the freedom of speech, which is a basic and fundamental right to the Constitution. This freedom is not absolute. The Constitution does not protect hate speech. The government has the power to regulate certain forms of speech, such as imminent lawless action, fighting words, obscenity, defamation, and commercial speech. Those are categories of speech that are not protected by the First Amendment and that the government is free to regulate. Normally, any restriction on a person's freedom of speech that is based on the person's expressive conduct is judged under the standard of strict scrutiny. Strict scrutiny means that in order for a law to be found constitutional, it must be narrowly tailored to a compelling state interest and be the least restrictive means possible. Very good, very good. In analyzing whether a person's freedom of expression has taken place, it is necessary to first evaluate whether speech has taken place. This is the conversation about forums. I sent an article in the Telegram chat that's 60 pages long. This is a very difficult concept in reality. Let's see how they keep it simple. Smiley on the bar. It is necessary to first evaluate whether speech has taken place. Case law is drawn to see case law, not the Constitution. Case law is drawn a distinction between public areas, which are known and historically popular for being a place where people express themselves, such as a park, a courthouse, where citizens are afforded the most protection under the Constitution. There are also non-public areas, such as someone's front lawn, and there are semi-public areas, such as government buildings like the IRS. In public areas, the government has the right to implement certain time, place, and manner restrictions. These restrictions must be content neutral and must be substantially related to important government interests. They need not be the least restrictive means and must leave open alternative forums for the expression to take place. So time, place, and manner in a public forum is going to be heightened intermediate scrutiny, right? Where important government interest with alternative forms of expression. They talked about public and non-public forums, right? A public forum is a sidewalk. A non-public forum is me right here in my kitchen. Now, they glossed over the intermediary, and it's very difficult when they said semi-public, because that could be traditional public forum, that could be a non-public forum that, I don't mean traditional. Traditional public forum is a sidewalk. That could be non-public forum designated for public use or a limited public forum. There's some things that are like that, like a prison, a military base, the inside of a teacher's mailbox, the office of a government agent. Those are kind of semi-public forums, like they were saying. They're like limited public forums. Or if the University of Miami, a private school, has a public event, like a debate, then that would be a non-public forum designated for public use. And in that case, it's time, place, and manner, content neutral. But if it's like a limited public forum or semi-public forum, it doesn't need to be content neutral. It needs to be viewpoint neutral, which is even more relaxed. So that's a difficult conversation, but I just wanted to say that and just let you know that, like, he didn't say any of that, and he still got the model answer. Just know public forum is where you have the most constitutional protections, and then they can not have content-based restrictions, but they could have content-neutral restrictions so long as they're time, place, and manner restrictions that are in line with intermediate scrutiny and have alternative means of communication. Okay. John and his parents can argue that John was engaging in constitutionally protected First Amendment right of freedom of speech while I created the website. While the school could argue that this type of expression constitutes imminent lawless action or fighting words, that argument would likely fail. Imminent lawless action exists when a person's express invites or when a person expressly invites an immediate breach of the peace. Imminent lawless action can occur when a person is on a podium in a public place yelling, trying to get everyone that walks by to band together and immediately overthrow the government. Fighting words are words that are said directly to a specific person in order to get them to engage in a fight, such as swearing obscenities in their face. As a website, John's language constitutes neither the aforementioned. Under the First Amendment, John's entitled to his opinion about the teacher. His parents could argue that John did not directly harass, intimidate, or try to get the classroom to attack him while he was in school, and that he was just expressing his disdain for the professor. The school will argue that by putting the words "Mr. Smith must die," that the student was engaged in behavior that constitutes hate speech akin to fighting words. The school will argue that they have a compelling interest in thwarting physical violence on campus before it occurs. And under the parent locus doctrine, the schools must step into the shoes of the parents while the children are at school and regulate their behavior accordingly. That's a very minute thing that's I've never seen tested ever, but it's true. The parent locus doctrine means that schools kind of can act like parents. Grace, I'm sure you know this. Your daughter's ever been disciplined? So I'm sure she hasn't. Grace and her parents can also argue that the fundamental right of freedom of speech has been violated via the substantive due process clause of the 14th Amendment, which makes the First Amendment applicable to the states, right? The 14th Amendment is what applied First, Fifth, and the other constitutional amendments to the states. Under due process analysis, because freedom of speech is a fundamental right, the school's action will be judged under strict scrutiny. John would also argue that his fundamental right to access the courts has been violated via the procedural due process clause, since he's been suspended without being heard by the court. Right? When they said notice and hearing, that was all implicating fundamental due process. This argument will likely fail as the school provided him with the hearing, right? So they did that and determined that the photograph was a joke. John and his parents can argue that the student policy by saying that it is a content-based restriction on speech and should be evaluated with strict scrutiny. While content-based rules will be measured under strict scrutiny, rules that are content neutral and apply to everyone across the board are standard of rational basis and will be struck down if ambiguous or arbitrary. A law passes the rational basis test if it is rationally related to legitimate government interest. The burden is on the challenger. The government will argue that legislation is neutral on its face and therefore the rational basis should be applied. The government will argue this regulation, at the very least, rationally related to safety, children, of the schools, and the kids. The parents can counter that it's irrational and arbitrary. Additionally, even if the law is content neutral, here we go, it cannot be vague or overbroad. A law is vague when it does not provide people with notice of what behavior is prohibited, and the law is overbroad if it prohibits more speech than necessary to achieve the goal. Even if it's found to be content-based, which is unlikely, the schools will have a valid argument related to achieving a compelling interest of safety. They can argue that's the least restrictive means, and they would most likely prevail if the speech had taken place during school. While the Constitution does grant citizens freedom of speech, schools are granted the power of greater restraint from speech that takes place in school by their students. The parents can argue that the school's right to regulate speech does not apply to a website that John created on his own while not in school, and that is a pretty decent argument. They can argue that the harassment, intimidation did not take place on school grounds. Additionally, the parents can argue that the law is vague because it does not define exactly what constitutes harm. They could also argue it's overly inclusive as it does not allow to be punished, but it allows them to be excluded from other extracurricular activities, right? It's overbroad. The school will argue that these rules are necessary to keep the school safe, right? They didn't even come up with the conclusion. They just told you all the arguments on both sides, and this is a great discussion to have. This was a First Amendment, time, place, and manner, content-based, content neutral, different levels of scrutiny. They also brought in due process. They talked about non-protected speech, and they talked about different forums, and then they had the discussion of, is it on campus, is it regulable, or is it off campus, is it non-regulable? I think the kid's going down. I think there's enough of a nexus between the website and the school and the education that this is speech that could be regulated under the Constitution. I do think that he's also going down, and they provide him notice and hearing, and that the kid's not going to be allowed to go to extracurricular activities because he's a punk ass kid. I went to public school, and it seems to be that that's how it goes. But there's definitely an argument for both sides. And then Mr. Smith is coming out with some IAD claims and some ethical issues. Excellent. All right, we're gonna do two more. We're gonna take, not too much longer. I know all of us are weary, but as Matt Beckerman said yesterday or Thursday, and as I say all the time, you want to practice being fatigued. You want to push yourself to having to perform when you're tired. That's what they do in the military. They'll make you stay up for 48 hours and then they'll give you the test. And you're delirious at that point. But it's like, yeah, that's what war is like. You might be up for 48 hours and then have to fight the battle. So that's kind of what we're doing right now. Think about it like that. We are at the end of this, we're going to do two more and we're all fatigued. Trust me, I don't like reading these either, but this is extremely valuable. All right, let's see if I could find one from this year that kind of fits the bill of what I'm looking for. Yeah, why not? Federal con law. Okay, this one I actually assigned to you guys as your essay assignment. I don't think it's an extremely tough essay. I hope you guys did fine on this. It definitely has implications of standing, time, place, and manner. Yeah, that's what it is. There's another time, place, and manner one. You see, very similar to the one we just did. Let's go to this year. Sure. This one right here. This one I think I assigned during the November course. Is that correct? Anyone who was in the November course saw this one?
I think so.
Yeah, I think I assigned this for the November course. For the, sake of time, I'm going to go over quickly, or so I could go over a Con Crim one, but it's very similar. This one is probably going to be talking about due process, equal protection, and things of that nature. United States Constitution. Okay, and look at this part right here. We would be crazy not to pass this bill. Federal highway funds are the source of 30% of Florida's Department of Transportation. It's a top priority. Congress, right? Congress found that driving interferes with this. It also found this. So the United States government enacted the law. It directs them to do this. So now we have a different issue here where the United States government is enacting the law, not the state of Florida. This is when we bring up Commerce Clause, Dormant Commerce Clause, anti-commandeering, right? Because we're talking about reduce the funding. So it directs them to reduce the funding, That's so reminiscent of 10th Amendment, and the federal government can induce, but they cannot compel states to enact legislation. They cannot commandeer them. So they can bribe them and say they're going to reduce funding, but they can't force them to. So I feel like this is going to bring up Commerce Clause, Dormant Commerce Clause, and maybe anti-commandeering clause. Not necessarily sure. I didn't, looking at it just like y'all, but I would recommend to look at this essay in this model answer carefully after class and for the future. And I think you all are understanding the point of why I did this, is to show you how valuable this is, to go over essays and model answers. And it's not a long assignment. It's just for the sake of reading and familiarizing yourself and like, wow, I've seen Kluger Doctrine come up 3 times by now. I've seen, whether a law can be enacted. I've seen vagueness and overbreadth. These are things that if you don't know well, you really need to know well because they are heavily tested. So let's just kind of look at this model answer, see what they were talking about. Standing. Again, I say they start with standing a lot. Do they have standing? Is it actual and imminent injury? Is it causation and damages? They say they have standing. Now this one talks about enactment of Congress's power to tax and spend. It's more of a federal issue. Broad taxing and spending powers. This could be Article 1. It could also be under the 16th Amendment. Broad taxing and spending powers. So here we go about what I was talking about, the conditioning. Congress has stated that we'll reduce states by 10%. While Congress cannot force states to enact laws, under the anti-commandeering principle, Congress can condition funding on the enactment of the law, right? So make sure you understand that anti-commandeering. The Congress cannot force states to enact law, but they can condition it on funding. Commerce Clause, see, this is one of those essays. This is all federal. These are the federal issues. I really wanted to show you all the diversity in common law questions, because someone asked me at the beginning of class if there's a blueprint for a common law essay. I'm like, the Florida blueprint would not do anything on this one. This is all federal. So taxing and spending is a near plenary power. Congress can set limitations on commerce so they can regulate the channels, instrumentalities, and economic activities that in aggregate have a substantial effect on interstate commerce. So they're talking about, they're regulating under Commerce Clause. It's reasonably related to alcohol-related crashes and all these different things. So it's probably a proper exercise under the Commerce Clause. Then they do an equal protection. So 14th Amendment incorporated to the United States government by the 5th Amendment. That is called reverse incorporation. The 5th Amendment is incorporated to the states via the 14th, and the 14th Amendment equal protection is incorporated to the federal government reversely via the 5th. Super difficult concept. If you want to learn more about that, I would do a tutoring session with Matt Beckerman, not me. Okay, but that's the concept here. So equal protection, suspect classes, race, alienage, national origin, right? Suspect classes, laws that unequally impact person on gender, illegitimacy, are given intermediate scrutiny, and such. Ooh, targeting men under age 34. I am 34. This doesn't even target me. But that would be intermediate scrutiny because it's targeting men, right? We can understand scrutiny levels. Men over 34. Yeah, I'll never trust a man over 34.
Oh, Andrew, I think Grace didn't get what you said. Like, you said reverse something.
Oh,
Yeah, the name of
incorporation. It's called reverse incorporation. It might not be reverse. It might be like a bigger, better word, but reverse incorporation, meaning that the 14th Amendment is the 5th Amendment is incorporated to the states via the 14th. Everyone knows that due process is a federal thing, but then they wrote the 14th Amendment to apply First Amendment, 5th Amendment to the states. So 14th Amendment applies due process to the states. Now, 14th Amendment also spells out equal protection. So that's actually a state issue. But then equal protection is reversely incorporated to the federal government through the 14th to the 5th, right? Like the 14th incorporates the 5th, and then the 5th incorporates the 14th. They do it back and forth. So the 5th Amendment applies to the states via incorporation, and the 14th Amendment equal protection applies to federal government via reverse incorporation. I can't believe I just explained that. All right, so due process is simple, substantive and procedural. Due process, procedural is notice and hearing, and substantive due process is the right to public jobs, benefits, and licenses that they may not be deprived of a fundamental right, including the right to vote, freedom of speech, right to privacy, right to interstate travel, right to contraception, marriage, procreation, education of children, raise your family. Those are all the fundamental rights. Now this one gets into some, tough subjects. I'm telling you, these are hard essays. This is going to be 10th Amendment. Let me read this one, and then I'll do one more essay, which is going to be about 4th, 5th, and 6th Amendment, and then we'll call it a day. All right, police powers. So federalism provides that the powers of the government of the United States are to be divided between the states and the federal government. The states are not to encroach on the federal government's powers, and the federal government is not to encroach on the state's powers. States, not the federal government, have police powers. This means that states are afforded the sole power of legislating for the general health, welfare, and safety of their citizens. The state's police power includes the right of states to provide for education, criminal laws, police, firefighting, education, etc. So that's encroachment. And then anti-commandeering. The federal government may not commandeer the instrumentality of the states. In other words, the federal government may not order the legislature agencies to enforce a federal law. This rule was developed in court, and basically it says that the federal government cannot compel states to enact law, but they can induce them through conditioning and funding. Now, this was a great essay for me to show because look at the first two essays we did. They were all about enacting a law in Florida Sunshine Law. We actually didn't do homestead exemption and Florida Sunshine Law. Don't worry, by the end of the class, you'll have been assigned essays that go over them deeply. Those are absolute subjects you need to know and need to know well. It's just, we did this at random. We didn't happen to see any Florida Sunshine and homestead exemptions, but you must know them. Create multiple flashcards for Florida Sunshine and for Florida homestead exemption. Florida Sunshine law means that all governmental meetings and decisions and policies need to be open to the public. The public has a right of access. The only exception is if it's 2 legislators in a private unplanned meeting. That's an exception to the Florida Sunshine laws. We have open government, minutes, meetings, communications, all that. So if there's anything that's superly overly private, it's going to implicate Florida Sunshine law. The best defense the government can make is their protected right to privacy in Florida, but that's probably not going to succeed because the Sunshine law says that all governmental proceedings need to be open access to the public. The other one besides the Sunshine law that you must know is the Florida homestead exemption. In Florida, primary residences are protected to half an acre inside a municipality, 160 contiguous acres outside of a municipality. They're protected from judgment creditors, except for mortgages, liens on the property, and taxes or government judgments. So Uncle Sam or, claims on the actual property itself. Homestead exemption, it applies to one property. And if you sell the property, but maintain the funds to buy a new property, then that'll be covered by homestead exemption. Your wife, your kids all are protected. Your minor kids are all protected by the homestead exemption. They cannot divest your homestead from you in a will or anything like that. There's a lot about homestead that we'll go into. There's also homestead as a tax deduction. You can take deductions from your house. One second. I wanted to show the class this. I don't know if you can see this, but this is the letter I just got in the mail the other day. This is the letter that says your homestead exemption is cool and you don't need to do anything, but you have to cancel it. And I'll read this to you. You must cancel your homestead exemption if the property is rented, the property is not the permanent resident of the original applicants, the original applicant has homestead exemption on another property, the spouse of the original applicant has homestead exemption on another property, the original applicants receive a permanent residency benefit or tax credit in another state or Puerto Rico, the original applicant has passed away, or the original applicant transferred ownership of the property by executing a deed but did not record it with a clerk of accounts. To cancel your homestead exemption, complete, sign, and return your automatic renewal receipt. Improperly claiming homestead exemption will result in tax liens up to 10 years plus a 50% penalty and 15% interest. So it's a real thing, the homestead exemption. I have it on my home, and they send you a letter every year that says it's going to automatically renew unless you're legally obligated to cancel it. And if you are legally obligated to cancel it, you better cancel it or we're coming for you. All right, so I'm going to do one more essay pretty quickly. Not something super hard, but something super important. And that's this concept of con crim law. And I might be giving away an essay that was assigned or an essay that's up and coming, whatever. It's just helpful. You still got to write the essays. So crim law and constitutional criminal procedure. Very familiar with this essay. So what happens here is we got this guy, David and Jake. They're driving motorcycles, and one of them runs into a lady. Now, the lady was wearing a dark shirt and was walking across the street, and it was at nighttime. They want us to argue under the specific statute that vehicular homicide is defined as the killing of a human being caused by the operation of a motor vehicle in a reckless manner likely to cause the death of a great bodily harm. Vehicular homicide does not require that the person knew the accident resulted in injury or death. Discuss whether facts would support convicting David and Jake of vehicular homicide. This one is very much like a UBE type essay, an MEE essay, where they give you a statute or ordinance and they want you to talk about it and go both ways on it. So that was the first part of this essay, was just saying, like, Jake would argue this, David would argue that. You know, the plain text of the statute said likely to cause the death. These two people were having a motorcycle race. Is that likely to cause death? Also, the lady was in a dark gray sweatshirt, so maybe you argue both ways. And then you say, well, David caused the accident, and Tommy, or whatever his name is, what's his name? Jake wasn't even caused it, but they were acting in concert. They were doing an extremely dangerous activity together so they could both be held liable, like if you're drag racing. There was that whole conversation. You see how they did want you to do something pretty different on this essay, which was look at a statute and analyze it. But that's only the first part of the essay. The second part of the essay is all about criminal procedure, 4th, 5th, 6th Amendment, all about warrants and exceptions to warrants, Miranda rights, search and seizure, things like that. You do need to be familiar and comfortable writing that type of essay. Unreasonable search and seizure, arrest without a warrant, exceptions to warrant, impermissible searches, all these different types of things. They do come up. Now, I teach that in federal law. I send everyone on the in this class like two videos that Matt Beckerman and I made, which are one going over all the federal crim pro considerations, 4th, 6th Amendment, and then the other one is going over multiple MEE essays. Now, those MEE essays are not Florida essays, but it's the exact same law. This is federal law. This is 4th, 5th, and 6th Amendment. The only important consideration is that Florida has an express heightened right to privacy. So here we say, I'll kind of read you here. The woman dies at the scene. Rest in peace. Hope her family does well. After hearing this, Dave texts to Jake 2 messages. I need to know if you talked to the police about me. Did you tell the police I killed the woman last night? Police officers investigating the incident set out to talk to all the registered owners of motorcycles in the area. They intended to knock on the doors of owners' residences and see if anyone would speak to them voluntarily. David was standing on the sidewalk in front of his apartment smoking when he saw a police officer drive towards him. The officer saw David, whom he recognized from a driver's license photo as a registered owner of the next motorcycle on the list. The officer parked in the parking lot and approached David. As he grew closer, he smelled marijuana. When the officer was about 10 feet away from David, he was sure the smell was coming from Dave's cigarette. He told David not to move. Dave did not have a prescription for the marijuana. That's very important because marijuana is medically legal now in Florida. He flew the cigarette on the sidewalk, put his hands in the air, and began to walk backward towards his open front door while the officer repeatedly told him to stop him. David ducked into his home and the officer followed him. In the kitchen, the officer took David down and told him he was under arrest for misdemeanor marijuana possession and resisting without violence. While the officer was handcuffing David, he noticed 2 grams of marijuana on the kitchen counter, which he collected as evidence. Plain view. The officer then went outside and collected the cigarette that Dave tossed on the sidewalk. The officer performed a field test, and what do you know? It was marijuana. Right before placing David in the patrol car, he searched David and recovered David's cell phone from his pocket. Looking through the unlocked phone, he found David's 2 texts from Jake. That's a little bit deep. There's an argument. I just saw that's how drug dealers are getting caught now. It's all through the phone. They could just do they basically find the guy who bought the drugs. They sync up his phone to who he's contacting the most with. They figure out that the guy he's contacting the most with is the drug dealer. Then they put a signal out on his phone and they see him, what he's up to, and they can put a lot of pieces together. So just so you know.
Andrew,
Yeah.
I have a question because I remember in my criminal procedure class, like they said that they can't really like look through your phone. Like they can take possession of it, but they
Right.
can't like open it up and search things. So
100%.
like,
And we're going to get there with this essay. This right here is excessive. You can't go look through the phone and do an impermissible search. That is invasion of privacy. That's unconstitutional. I'm just saying the laws are peeling back a little bit on how protected you are in your phone. Yes, you are absolutely protected in the messages. They can't go through and look for your phone. But what I'm saying is there is a trend right now in certain jurisdictions where they're allowing them to look at the communications with other phones, not the content, but the act of communicating, and are able to put together, oh, this guy's driving around. Now,
okay.
let's throw that out of here because we're just thinking about the essay. This right here, totally agree with you. Looking through the phone is going to be too far. Now, on an essay, you're going to argue both sides. But right now, as the law stands, I'm absolutely in agreement with you. You can't look through someone's phone and find out information without their consent. But you might be able to do some other things about who the phone has been contacting with and not looking at the actual content of it. But let's scroll back. So right before he looked through the phone, like Gabby said, that's probably impermissible. Without saying anything, he held the phone up to David to display the text, right? because that's how he unlocked it, right? He put the phone up to his face and unlocked it. That's problematic. David explained she was in the middle of the street. I didn't see her. I never meant to hurt anyone. So, okay, he wasn't using it to unlock it. The phone was already unlocked. He was using it to show David the text, and now David admitted to it. So here, it's an admission. Maybe that's not Miranda. Maybe, it's voluntary. We're going to have to talk about Miranda. It's also going to implicate, even if the earlier finding was impermissible because it was without a warrant, now maybe we have the exception of inevitably discovered, right? Inevitable discovery. You're inevitably going to discover this anyway, so maybe that's a good argument. While Dave was taken to jail, a different police officer arrived at Jake's home as he was also registered on a motorcycle. Jake voluntarily allowed the police officer inside the home and told the officer everything about the previous eating. That's what I was actually getting at. That seems to be the inevitable discovery. Maybe the way that they found the information from David was total violation of a Fourth Amendment right to privacy and a violation of his Fifth Amendment Miranda rights. But now the other dude ended up admitting everything anyway voluntarily, so maybe it's inevitably discovered evidence. No matter what, I actually assigned this essay to y'all, so I'm going to go over it quickly and not word for word. But I want you guys to all write this, and I want you to really focus on, do I know Fourth, Fifth, Sixth Amendment? Do I know unreasonable search and seizure? Do I know Miranda rights? Do I know the process for voluntary versus involuntary, for when you're in custody, for when you're not in custody, for the exceptions to the warrants? All those things we're going to make sure we know well. So the first part I talked about, be confident that you can write this type of essay where they give you an act or ordinance and they want you to apply it. It'll be, this is what the ordinance says. This is what we're talking about here. Now we're talking about the constitutional interactions, and I'll finish class up with some light reading. Under the Fourth Amendment to the United States Constitution, Jesus, this was a real essay. I really wish the FBBE would edit this for grammar's sake, but I guess that would take them 7 minutes too long. Under the Fourth Amendment to the United States Constitution, people in the United States cannot be subjected to unreasonable searches or seizures. The key question is reasonableness. Whether a search or seizure is reasonable will depend on whether the government has probable cause to believe a crime has been committed, or that evidence of illegal activity has been found. There's a less exacting standard for Terry stops, reasonable suspicion, which allows law enforcement to pat down a suspect if they have reasonable suspicion they have a dangerous weapon. Any evidence that's obtained as a result of a legal search or seizure may be suppressed during the suspect's prosecution. That's the exclusionary rule. Key point, Fourth Amendment, unreasonable search and seizures, anything that's obtained as a violation shall be excluded. Also, we'll follow with the fruit of the poisonous tree doctrine. So here, you guys are going to write this essay, so I don't want to get over it too long, but there's probable cause because he's smoking a marijuana cigarette. So he had the right to arrest him. So the officer followed David's apartment without a search or arrest warrant. Since he lived there, he would generally need an arrest warrant, not a search warrant, to enter the apartment to make the arrest. David would argue that this arrest was unlawful and violated his Fourth Amendment rights because the officer did not have a valid arrest or search warrant, and therefore any evidence of crime found as a result of the legal arrest, the marijuana inside the apartment, the incriminating message of the phone, are fruit of the poisonous tree. Remember, exclusionary rule, anything found as a result of that, what's found in violation of the exclusionary rule, will also be excluded under the fruit of the poisonous tree doctrine. The fruit of the poisonous tree doctrine is meant to have a deterrent effect on law enforcement so they do not violate the Fourth Amendment, and provides that any evidence collected as a result of an illegal arrest or search cannot be used as evidence. However, there are several exceptions to this doctrine. In other words, even if it was illegal, the officer may still be able to use that evidence. What I was forecasting would be inevitable discovery doctrine. The officer will argue that an exception to the warrant requirement, the hot pursuit exception, right? So again, exceptions to warrant. Please memorize the spaces mnemonic. Search incident to arrest. Plain view doctrine. Automobile exception. Consent. Accident circumstances / hot pursuit. That's this right here. And then stop and frisk. This is all he's doing. He's going to go around these things and say, the question is whether any evidence found as a result of legal arrest can be suppressed. Now we talk about the marijuana inside the apartment. If an officer is illegally inside someone's home, they do not need a warrant to seize any items that are in plain view. Here, it seems like it was in plain view. And then the marijuana sidewalk. After arresting David, the officer went back outside and retrieved the marijuana on the ground. It would not be excluded. It's because the officer's seizure of the marijuana did not violate the Fourth Amendment rights. He had no reasonable expectation of privacy on the public sidewalk. And bro, if you're throwing that marijuana cigarette out, you gotta throw it far. All right. the contents of the cell phone, and this is exactly what Gabby was saying. And I wasn't trying to disagree with her. I was just saying there is a alarming trend if you're a drug dealer into what they can and cannot do with your cell phone, but absolutely not as of today can they look through it and read the text without a warrant. Absolutely not. So here there are potentially two issues related to the government trying to use David's phone. First, it was seized as a result of David's illegal arrest, and therefore it's through the poisonous tree. However, one exception is the inevitable discovery. They would have inevitably been seized regardless. Here, the officer would likely have obtained it, and that could be excluded on the poisonous tree doctrine. The second issue is that he went through the phone without first obtaining a search warrant. Although officers generally may search a person as a search into a lawful arrest, courts have held that due to modern technology and the amount of information we have on our cell phones, especially smartphones, people have a reasonable expectation of privacy in their phones, and police generally need a warrant to search a phone. Dave would argue that even if the officer could legally seize his phone, he needed a warrant before going through his phone, right? You could seize it, but you can't go through it. Therefore, David would argue the text must be suppressed on the fruit of poisonous tree doctrine because the officer searched his phone without a warrant. Law enforcement argued that while generally people have a privacy interest in their phone, he did not because it did not have any passwords and it wasn't locked. It wasn't password protected. He would not have a re-op. This may be a close call, right? That's what me and Gabby were saying. Like the way things are going, this is a closer call than you would think. 2 years ago, 4 years ago, no way. But nowadays, they're kind of doing some phone work. But still, I agree with Gabby on this case. No, this was too much. But he said it's a close call. We find that I have a reasonable expectation to unlock phone, but it won't matter as it would ultimately come in under the inevitable discovery doctrine. Law enforcement argue that they have eventually sought a warrant for the phone and that everything that they found is going to be admissible. And then we have the confession. They would also try to admit his statement, she was in the middle of the street, I didn't see her. He could try to exclude this evidence due to his violation of Miranda rights. Under the Fifth Amendment, any person who is in custody and undergoing interrogation must be given Miranda rights. Otherwise, anything they say can be excluded. A proper Miranda warning gives a suspect notice that they have the right to remain silent. Anything they do or say will be held against them in the court of law, and they have the right to an attorney. If they cannot afford one, will be provided for them. Here, it doesn't seem like he got his Miranda rights. So if he can show he was in custody and the statement was a result of custodial interrogation, he can have it suppressed. Whether someone's in custody depends on whether a reasonable person in their situation would have a reasonable expectation they could leave. At this point, he had already been placed in handcuffs and was in the car, thus he was in custody. Whether something is interrogation is whether police make a statement or action that would reasonably make a suspect make incriminating statements. Although they didn't ask him a question, he showed them the text that, put the thing in his face that made him make the statements. Because this was a custodial interrogation, and because the officer did not first read David his Miranda rights, David's statement confession would likely be excluded from evidence. And then the final last thing is Jake's confession. It should also be noted that Jake's confession is admissible. Jake voluntarily let police inside his home, consent is an exception to the search seizure requirement. There is nothing indicating that Jake was in custody, and Jake voluntarily told the officer about the prior evening. Thus, Jake's statements are admissible against both Jake and David. So, first and foremost, that's an assigned essay for you all that you all have. So, for you all who's telling me I can't write these essays, it's going to be too difficult, I'm telling you, at least one essay, you should know what you should be writing about. Fourth, Fifth, Sixth Amendment, the marijuana cigarette, the inevitable discovery doctrine, the ways that you can overcome needing probable cause, the spaces mnemonic, and then you can really knock that essay out of the park. The purpose of today, and I know we've gone 20 minutes over, sorry for that, but I really want to help you all crush this test, was to demonstrate how diverse common law questions can be. It's really 3 subjects: Florida law, federal law, and criminal procedure. And they could go any direction with them. So what I want you all to do is continue this exercise. It only took us less than 2 hours, and we were able to go through 5 different essays. Just go through the model essays, read the prompts, read the model answers, see if there's anything in there that's unfamiliar that you don't know, and especially take note of the issues that you see over and over again, because those are the ones that are most likely to be tested on test day, and those are the ones you really do need to know cold. Overall, our questionnaires are pretty comprehensive. You can memorize the questionnaires. You should have the tools necessary to write these essays. One thing, and the last thing I'll leave you on, is the truth. I just took the UBE because, I'm a student of my craft. And I wrote the MPT section for the MEE, which is similar to that. They like give you all these facts, and then you have to write essays, but you don't need to know any outside law. It's a closed universe essay. And it was a 3-hour essay, and Matt Beckerman was teaching it. I was in the course. I'm teaching y'all Florida. I'm doing my own thing. I kind of overlooked that thing that I preach, which is you need to do practice essays. Because I took the MPT 3 hours. I spent 2 hours on my first essay, one of the greatest MPTs ever written. And then I only had 1 hour to write my second MPT, which you need an hour and a half to write. I have never in my life been more like, I was crazy. And I remember thinking like, me, I'm built for that. You know, I'm a speed demon and I teach the law for a living. I was able to churn out a good essay in an hour. I would never, ever, ever want to put one of my students in that position, ever. I hated the way I felt. Like, I was writing into the last second and putting a period. I was doing no editing. It just didn't feel comfortable. And why is that? Because I didn't write practice MPTs. I didn't practice the timing and simulating the circumstance. So I took too much time on my first essay, and it might have been great, but it didn't give me enough time on my second essay. And the only reason for that is because I didn't write practice essays. That's why I'm such a proponent of writing practice essays. I say this every year. If you write 20 practice essays, your 21st, 22nd, and 23rd are going to be piece of cake. It's going to be totally natural. If you've only written 1 or 2 essays and you try to write 3, 4, and 5 on test day, there's a good chance you're going to run out of time. You're not going to be able to articulate something that you think you know, but you don't know how to write. And it's just not going to be as ideal as it could be. So I highly encourage everyone to do the 2 things. To be a great writer, you have to be a great reader. So read all the essays and the model answers. And then to be an extremely great writer, you have to be well rehearsed. So practice, practice, practice. We're moving on next week to real property, extremely difficult subject. So please take this weekend to write your con law essays, to review and reinforce contracts, torts, and con law. And then we're going to hit the road with real property on Monday.